Well, good Tuesday morning to everyone, or potentially Tuesday at noon out east. Welcome back to our 6th webinar here in our ERISA webinar series. We've got more of a advanced topics today. We've got going to be doing a little bit of a deep dive into subrogating fully insured and some non-ERISA plan issues. So we're going to kind of cover it like this, and we're going to start out with the fully insured plans, talking about how ERISA preemption works and give you guys some ammunition to use the next time you're dealing with a fully insured and issues like made whole, and how that preemption may still work in our favor. Then I'm going to pivot to a conversation about choice of law and choice of law provisions and how they can help you subrogate for fully insured and non-ERISA plans throughout the country. And then finally, if we're stuck with made whole, Nancy's going to give us some tips and tricks on how we can best negotiate or handle those claims so that we're still recovering even if we're dealing with made whole. First, I'm going to kick it over to Catherine, and she's going to start off talking about ERISA preemption.
Thanks, Ryan. So I think everyone on the webinar, and certainly if you've listened to any of our past webinars, should be very familiar with the preemption rights that are afforded to self-funded plans. But today we're going to take a bit of a step back and talk about when are we still going to be dealing with preemption, even if your plan is a fully insured ERISA policy. And so we're going to start off with some of the congressional record from when ERISA was first passed. It should be stressed that with the narrow exceptions specified in the bill, the substantive enforcement provisions of the conference substitute and are intended to preempt the field of federal regulations, thus eliminating the threat of conflicting or inconsistent state and local regulation of employee benefit plans. This principle is intended to apply in its broadest sense to all actions of state or local governments or any instrumentality thereof which have the force or effect of law. So what this boils down to is that Congress intended all of this preemption to be broad, and the preemption is not entirely dependent on the plan's self-funded status. The Supreme Court has reaffirmed what we saw in that congressional record, which is that the preemption clause in ERISA is, quote, conspicuous for its breadth. And so there's a 3-part analysis that you'll go through to determine whether some kind of state law, be it case law, be it statutory law, is preempted. And so the first question is one that hopefully we're all familiar with, which is whether or not the law relates to an employee benefit plan governed by ERISA. And so it's pretty well settled that regulations concerning subrogation and reimbursement, including common fund and made whole doctrines, do relate to employee benefit plans. So pretty much any law, never say never, but pretty much every law that plaintiff's counsel is going to throw at you to try to reduce or eliminate a subrogation interest is probably going to fall within this first bucket of relating to employee benefit plans. Then what you need to look at is whether or not that regulation is saved because it regulates insurance. And so this is what's really going to matter for those fully funded plans, because as you can see in the next bullet point, there is an exception for those self-funded plans which can't be deemed to be insurance. And so we're not going to deal with that much today. But obviously, that's a lot of cases, certainly cases involving self-funded plans, you're largely going to be relying on that deemer clause and not the savings clause. But today, what we're going to be focusing on is the savings clause. Do certain state regulations actually regulate insurance, or are they just generally applicable laws that are directed at many industries that may not be saved under ERISA savings clause. So those fully funded plans are going to be preempted if the law relates to the employee benefit plan, but does not regulate insurance. And then self-funded plans, generally speaking, the preemption is going to apply so long as the law relates to the employee benefit. So the Supreme Court, as they often do, has laid out a multi-part test for what are you looking for when you're doing any kind of savings clause analysis. And so what the Supreme Court said in pilot life insurance is that they're guided by several considerations. First, they look to what guidance was available from the common sense view of the language in the savings clause itself. So essentially, you're looking at the text. What does the text mean? Second, they've specifically looked at case law interpreting the business of insurance under the McCarran-Ferguson Act in interpreting the savings clause, because that's another area of federal regulation where you're specifically looking at, is this something directed at the insurance industry? And then there are another 3 criteria under the Act. First, whether the practice has the effect of transferring or spreading a policyholder's risk. Second, whether the practice is an integral part of the policy relationship between the insurer and the insured. And the most important one in dealing with a lot of the regulations dealing with subrogation and reimbursement is third, whether the practice is limited to entities within the insurance industry. And so this is really where that savings clause gets narrowed in ways that a lot of people don't realize at first blush, because the regulation doesn't just have to impact the insurance industry. It doesn't even necessarily have to primarily affect entities that are actually insured. It has to be limited to entities within the insurance industry. So whenever you're being asked to consider a reduction for any plan, but in this case, specifically those fully funded ERISA plans, the first thing you're going to want to figure out is, even if you know that the state that you're working in applies the made whole doctrine or applies the common fund doctrine, what is the source of that regulation? Is it common law? Is it something that a court simply announced? Or is it statutory? And if it's statutory, in particular, you're going to want to look very carefully at the text of that statute. Generally speaking, many of these common law or judge-imposed case law reductions for things like the common fund doctrine have been found not to specifically regulate the business of insurance, and so often aren't going to be saved. And where those regulations are more likely to apply to your plan are when they are enacted by statute. So let's take a look at a few different states. And now, obviously, we can't cover every state in this webinar, but if you've got a question on a state that we haven't gone over, feel free to email us, and we're happy to talk you through some of the other ones. So we're going to start by going through a few of these statutory provisions. And so Indiana's anti-subrogation statute purports to reduce all, quote, subrogation claims or other liens or claims that arose out of the payment of medical expenses or other benefits in the same proportion to the claimant's recovery for comparative fault, for limits of liability, and it also imposes a pro rata reduction for attorney's fees and costs. So essentially, this is a form of the made whole rule, where if everybody agrees that the plaintiff, if limits of liability, if limits of insurance weren't an issue, would have gotten $500,000, but there's only a $250,000 policy. What this says is that the patient is only recovering half of their total damages. The plan should reduce its lien by half. It also needs to reduce for attorneys' fees and costs. So obviously, self-funded ERISA plans are going to preempt that statute, but fully insured ERISA plans are going to be subject to that statute because it specifically regulates insurance under the text of the statute. And I've included a citation for the Northern District of Indiana case that goes through that analysis of length. So, Pennsylvania. Pennsylvania prohibits subrogation in cases involving motor vehicle accidents. There shall be no right of subrogation or reimbursement from a claimant's tort recovery program. With respect to, it first lists out a bunch of specific statutory provisions. So it, cites the code for workers' compensation claims and things like that. And then it goes on to say, or benefits paid or payable by a program, group contract, or other arrangement. And this one's direct from the Supreme Court. So what the Supreme Court says is that there's no dispute that the Pennsylvania law falls within the insurance saving clause, because it directly controls the terms of insurance contracts by invalidating any subrogation provisions that they contain. It doesn't merely have an impact on the industry, it is specifically aimed at. And so this is this language from FMC is something that you can apply to a lot of different statutes across the board. Does it have an impact on the industry, or is it aimed at the insurance industry? And where you're regulating policy language, typically there's going to be a finding that that's at a minimum aimed at the industry. So Virginia, again, this one is statutory, and this one starts off very clearly, no insurance contract. And so that one has been found to be saved as to fully insured benefits, but there's actually a fairly interesting case where the plan was fully insured for vision benefits, but they were self-funded for medical benefits. And so the court had to go through an analysis of how the Virginia statute specifically interacted with each of those. And so the plan was permitted to recover what it had paid for medical benefits, which was, I believe, the more substantial of the two. Okay. So now we're going to turn to one where the anti-subrogation statute isn't statutory, and that's Arizona's anti-assignability rule. So that one does not regulate insurance because it's a creature of decision from the Arizona court. There isn't a specific statute.
And Catherine, can you break that down? Like, what exactly does, how the Arizona anti-subrogation rule, like what is it saying?
So what the anti-assignability rule or the anti-subrogation rule says is that the insurer or the payer of benefits isn't allowed to enter into an agreement by which they're going to be assigned the rights of the individual who's actually injured, absent some specific statutory exception. And there are a fair number of those in Arizona, including, I'll note here, if anyone is dealing with self-funded governmental plans in Arizona, those can get really tricky. There is a statute, it's ARS 12926, that allows government entities to essentially get around that anti-assignability rule, even though fully insured plans in Arizona can't. Those self-funded governmental plans, so even though they have nothing to do with ERISA, can get around that anti-assignability rule by statute. But interestingly enough, there are two different cases. One of them, the Low Piano v. Hunter case, was decided in 1992, and originally the appellate court in Arizona decided this statute doesn't mean that the governmental plans can recover, this statute really only means that if a government actually provides health benefits by being, say, a hospital or a more traditional provider of benefits, then they might be able to have a lien, but not the self-funded governmental plans. And so, much to my annoyance, this low piano case does not have any red flags on Westlaw. If you just look at it without knowing anything else, it looks like it's perfectly good law. Do not be tricked into thinking that. The legislature was actually quite disappointed with this decision and amended the law to specifically ensure that these self-funded plans would be able to pursue liens, would be able to pursue recovery. And that was acknowledged, and the legislative history is gone through in fairly extensive detail in Arizona Department of Administration v. Cox, which is a 2009 decision, which affirms that self-funded governmental plans in Arizona are not subject to that anti-assignability rule.
So to sort of recap, though, to go back, take a step back, is that the rule in Arizona is created by courts. It's a common law rule. Is not like the other statutes that we highlighted that were, in the insurance code, or they were passed by the legislature. This is just a judicial rule that's applied in Arizona. Similarly, California has one that's a little bit like that as well. But so the analysis then, Catherine, is different, right?
Exactly. Because the anti-assignability rule, this court-made rule, it's extremely broad. It doesn't talk about insurance specifically. Absent a specific statutory exception, it applies to everyone. And so it's a rule of general applicability rather than one aimed at the insurance industry, even if it has maybe even a disproportionate effect on the insurance industry. That's not enough for it to be saved under ERISA preemption. And so we'll turn to Texas, and we're headed back to one of these statutory rules, but this one's a little different than the ones we went through in the first set. And you'll notice that right off the bat, when it talks about a payer of benefits whose interest is not actively represented by an attorney in an action to recover for a personal injury to a covered individual, shall pay the attorney representing the covered individual a fee in the amount determined. This is essentially a codification of the common fund rule. But something that's important about this is that first provision, a payer of benefits. This is not text that is found anywhere in the insurance code. It's found in literally something called the miscellaneous provisions of Texas Civil Practice and Remedies Code. And it expressly applies to both an insurer as well as a number of other entities which don't have to be insurers, even if they perform similar functions like being a self-funded plan or a group hospital arrangement. But it doesn't apply specifically to insurers. And so because the statute doesn't apply specifically to insurers, it has limited enumerated exceptions and has an incredibly broad scope, unlike those first three statutory provisions that we were talking about in states like Virginia. That has been found, because it applies to payers of benefits, not to be saved. And so the common fund doctrine shouldn't apply regardless of whether your plan is self-funded or fully funded in Texas if it's an ERISA plan. Okay. And so, like we talked about with Arizona, when you're talking about judge-made rules or something that is, recognized as existing in the common law by a court rather than simply as a statutory matter, because the statutes have the ability to be aimed more directly at the insurance industry. They're going to be able to regulate language of policies and the like. these common law anti-subrogation rules generally aren't going to be saved and are going to be preempted even for fully insured plans. And so that's going to be true in states like Missouri and Nebraska, which has been repeatedly recognized.
So I think, right, to kind of sum this whole section up is that we shouldn't be giving up necessarily just because our plan is fully insured. We shouldn't treat that as if it were, you know, state law health insurance. It's potentially you've got the same argument for preemption, or different argument, but the same preemption, preemptive rights that a self-funded plan may have in some of these states.
Exactly. And so I think at this point, we're going to turn it over to Ryan for choice of law.
Thanks, Catherine. So now Catherine just got done, you know, talking to us all about federal law and preemption. But what do we make of choice of law provisions within an ERISA policy? You know, I will see, you know, I don't know if you've seen it, but, you know, a plaintiff's lawyer may pick up on the fact that the plan document has this choice of law provision way at the end that talks about, you know, applying a specific state's law. And they then make the argument that therefore there is no ERISA preemption because the plan chooses state law over ERISA. That's a fairly common argument that I'll see raised by attorneys out there. So it's one I wanted to look at here, and then we'll kind of transition into some of the other choice of law arguments that we can use in our favor for those fully insured and non-ERISA, specifically non-ERISA plans or policies. So if you look carefully, many policies or many plan documents, both ERISA and non-ERISA, will contain a choice of law provision that in maybe different ways elects a certain state's law to control the interpretation of the plan or in addition to ERISA. One of the examples that I pulled was a provision here that talks about basically the example provision was the coverage is provided pursuant to a contract entered into the state in the state of, in this case it was Michigan, and shall be construed under the jurisdiction and according to the law of the state of Michigan. So, and this could be in any policy. That's why I blanked out the states there. So how does that work? You know, how do we interact with Michigan law and ERISA? Does ERISA still control, or does the law of the chosen state apply? You know, and how do we best use these provisions to leverage our arguments? So next slide. Let's first address this issue regarding the conflict between a choice of law provision and ERISA preemption. How does this affect ERISA preemption? Well, for starters, what it does not do is allow state law to override ERISA and federal law. So the cases here are, you know, I've highlighted a few. There's actually a lot out there. And the courts are very aligned and uniform in holding that parties may not contract to choose state law as a governing law of an ERISA benefits governed benefits plan. So even if the plan provision is very specific and it says that you know this policy should be interpreted in accordance with Michigan law, the courts are not going to enforce that to the extent it conflicts with ERISA, or to the extent it undermines ERISA's broad preemptive provision that Catherine talked about. So here's, I would jot down a couple of these cases because they may come up. They certainly will something you may want to look at. But there's not been any courts that I'm aware of or that I found in my research that would allow for state law to somehow override preemption or override ERISA in general. Next slide. So now that we've established that the choice of law provision doesn't affect ERISA preemption, what does that mean? Well, is it just completely null and void? The answer is really no. There is some room here for that choice of law provision in an ERISA policy to function. And courts have said there is a purpose here for that provision, and it still provides for certain uniformity across interpretation for those issues that are not preempted by ERISA or not resolved by federal common law. For example, one of the cases that I looked at to kind of give you an example is, there was a life insurance policy that happened to be governed by ERISA, and there was a dispute over which spouse was entitled to it. Apparently, in the I think it was might have been that Durden case that we've cited there. In that case, the gentleman had married again, and there was a question of whether his first marriage was properly annulled or whether he actually got a divorce. And so the court said, well, he had designated wife number 2, but it's not clear if that second marriage was actually valid because he may not have been properly divorced. And so the court had to then turn to the choice of law provision and state law to resolve that specific question. So really, there are some peripheral issues that can still be decided using state law, even when you're dealing with an ERISA plan. But keep in mind that state law is really only reserved for those side or peripheral issues when we're talking about ERISA plans. So I think, next slide, I think maybe more where choice of law helps us is when we are dealing with either the states that Catherine covered where we have a statute that is going to be saved from preemption. In other words, the Indiana statute, the Pennsylvania statute, all of those anti-subrogation statutes that are potentially going to affect our rights of our fully insured plans, or in the cases of non-ERISA plans. That's where we're really going to want to leverage a choice of law provision. And that's where we're going to want to argue that, no, this state statute doesn't apply because the policy dictates that a different state's law should apply it. And generally speaking, it is pretty well settled in most states that a contract's choice of law provision that calls for a specific state's law, that state's law will be applied unless that state law provides no reasonable relationship to the transaction, or where it violates some fundamental principle of justice of the forum state. So in other words, if the policy was issued, in Wisconsin here to a Wisconsin insured and it has a Wisconsin choice of law provision, if there's an accident down in Illinois and they ask about choice of law, there's certainly a reasonable relationship to that choice of law provision in that policy. And so the courts are not going to simply set that aside because it chooses a different state's law than the court happens to be in. So generally speaking, those provisions are going to be applied. I guess the trickier question is, well, what does the choice of law provision really say? What's the scope of it? Because there are different types of choice of law provisions. I'll give you an example of the two main types. One is a provision that states that the policy will be construed or interpreted by the laws of the state of Connecticut, versus a policy that says that the policy will be governed by the laws of the state of Connecticut. Those are two very different interpretations. So maybe the leading cases is our known case from the Second Circuit, where the parties were trying to get around the New York's anti-subrogation law, General Obligations Law 5335, which basically prohibits any type of subrogation or reimbursement out of a state personal injury settlement. And I think in that case they wanted to actually just offset. But the policy there had a Connecticut choice of law provision. So, you know, in addition to arguing that the statute didn't apply because it was an offset, they argued that it doesn't matter because Connecticut law applies. Well, the Second Circuit looked at this and said, we generally do apply choice of law provisions. However, this provision only requires us to construe the contract pursuant to Connecticut law. It doesn't say that it's governed by Connecticut law. Therefore, they found that there was room here for New York's law to apply without violating the terms of the policy or the Connecticut's construction. So basically what they're saying in that construed by language is that, well, if there's an ambiguity in how we should read the policy, we might look to Connecticut law to construe that ambiguity. But here, that choice of law provision was not going to control over a New York law that applied to this particular settlement. Now you'll see a different result typically if you have this much broader governed by language. So the Medlar versus Regents group involved the Pennsylvania anti-subrogation statute that Catherine introduced earlier. And in that case, there was an Oregon policy. So because Regents is a Northwest insurer and they do a lot of business up in the Pacific Northwest. And so this was an Oregon policy that had a choice of law provision for the state of Oregon that the policy would be governed by the laws of Oregon. And in that case, the court applied Oregon law pursuant to that choice of law provision over the Pennsylvania anti-subrogation provision that's found in the motor vehicle financial responsibility law. And so I think you're going to want to make sure going forward that you understand which type of choice of law provision you're dealing with in your policy. And if you've got the governed by language, you have a very strong argument that you can get out of these anti-subrogation or made whole statutes that you happen to be in. Next, the other issue, maybe a threshold issue that you really want to look at when we're talking about choice of law is not necessarily in your policy, but it's the actual statute that we're dealing with. So, I do a lot of work with insurers that insure, trucking companies. And, the truckers will go around the country, and so they're traveling in Illinois one day and they're in Indiana the next. And then they're back to their home in Missouri. So you deal with these multi-state, multi-jurisdictional questions a lot. And so if that's something that you're seeing, or if you've got traveling employees that are covered by policies, this is something you want to pay attention to, because not every anti-subrogation statute is the same. Typically, the legislatures are looking to regulate insurers that write insurance in that state, because for the most part, a state legislature's governing authority is limited to the boundaries of that state. So in other words, the Pennsylvania legislature can't control what the Massachusetts legislature does. They can't regulate insurance policies delivered in Massachusetts. That's just not their role in our national system. So I want to target the Pennsylvania statute and the Georgia statute as one example. So we know that Pennsylvania has a statute that basically prohibits subrogation in cases involving motor vehicle accidents. But there's a line of cases here that have quite clearly delineated that the anti-subrogation provision cannot be applied to benefits that are recoverable by out-of-state insurers, because they're not covered by the statute. And then if you kind of read the statute back a little bit further, one of the other reasons why the Pennsylvania motor vehicle responsibility law doesn't apply to out-of-state insurers is because it doesn't apply to out-of-state drivers, because they're not registered, their vehicles aren't registered in Pennsylvania, which is one of the prerequisites to this to the particular law. I don't think I've cited the case here, but that's the Bridges versus Gary, and you can find that through one of the other cases I'll talk about later. So if you've got a policy or a driver that's based out of state and they get involved in a Pennsylvania motor vehicle accident, there's a good argument here that this particular anti-subrogation statute doesn't apply at all. The same is true with Georgia's made whole or complete compensation rule that's found in 3324-56.1. And that one is deeply embedded in the minds of all Georgia trial lawyers. Like, even if you're self-funded ERISA, generally they still will ignore you. So it doesn't matter. Their mindset is complete compensation rule applies to any accident, any claim in Georgia. But I will point you to, if you just trace the statute back a little bit further to some of the definition sections, there's clearly an exception in this statute for policies or contracts not issued for delivery in this state or delivered in this state. So in other words, if the policy isn't approved by the Georgia Insurance Commissioner, we've argued successfully in a couple cases, and I'll cite you a state trial court decision for what it's worth, maybe not much, but the judges that we've argued in front of have clearly understood that this exception means that these out-of-state policies, even setting aside a choice of law, if it's issued out of state, it's not regulated by this particular section of the Georgia code, and therefore the complete compensation rule will not apply. Next slide. Finally, I want to get a little bit creative, and this is going to maybe put you outside of the normal box that you're used to functioning in, and that is the ability to control our choice of law by dictating the venue. What do I mean? So in this instance, what I'm talking about here is traditional subrogation, where the plan goes out and files suit against the at-fault party. And this, I know this doesn't happen a lot. In most of our situations, we're dealing with, a lien or a reimbursement claim against the insured's recovery. And so our mindset may not be thinking about subrogation and going after the at-fault party. But subrogation in this instance allows us to be a little bit creative, because we're not necessarily limiting ourselves to the law where the plaintiff's lawyer is or where the accident happened, but we can be a little bit more creative. We could potentially file suit where the accident happened, or a lot of times, when I deal with traveling employees, they go back home and they get a lawyer in their home state, and that might be an anti-subrogation state, and then they settle the case, and then we're dealing again with a claim against that recovery in the anti-subrogation state. Well, think about filing your lawsuit, your subrogation suit, where the accident happened. Alternatively, we may not like the accident location state, and we'd prefer to file suit in a different state, maybe where the at-fault party or the at-fault party's employer is a citizen of. And so that allows us to then say, well, we don't like New York, so we want to get out of New York, but looks like we can file suit in a different state. Essentially, we could file anywhere you can obtain personal jurisdiction over the at-fault parties. So let's consider the scenario, just a hypothetical. You've got the New York accident, but you've got a Wisconsin at-fault party. So we want to avoid the potential application of New York GOL 5335 that's going to apply if they settle the claim in New York. So what we would do is file a subrogation action in Wisconsin against the at-fault party, and we are completely clear of GOL 5335. I'll give you another example. This is a case I've got a citation for because I handled it. And this was a tricky situation. We had a Wyoming accident. The at-fault party was in Montana. The insured person was in Kansas. And the attorney was in Kansas. And the policy was delivered in Pennsylvania. So if we kind of back up, Pennsylvania anti-subrogation for motor vehicles, Kansas anti-subrogation, Montana anti-subrogation. The only good state there for us was Wyoming, where the accident happened. Well, turns out we didn't actually get this file until after the plaintiff's lawyer had already settled pre-suit in Kansas. And so that Kansas lawyer said, go pound sand. In maybe not those terms, but wouldn't deal with us, basically said, look, Kansas is anti-subrogation and you've got a Pennsylvania policy, so Pennsylvania alternatively would also bar it in this incident, and therefore we're not going to pay anything. So what we did here was say, all right, so be it. We had placed the at-fault carrier, very important, this is a concept I'll touch on in a second, on notice prior to the settlement. And so we were able to file suit in Wyoming. And we filed suit against the at-fault carrier, got a little bit involved because everyone got brought in, even the party that had settled the case, the insured, and they all said, no, this is either Pennsylvania law controls here or Kansas law controls here, not Wyoming law. Well, the court did a little bit of a choice of law analysis, and determined that no, Pennsylvania's law, motor vehicle responsibility law, didn't apply. And typically the way that Wyoming courts address choice of law is that wherever the accident happened is what law applies. And therefore we were successful in being able to pursue the claim under Wyoming law, and basically had to have the parties pay twice. But if you're going to go down the route here of subrogating and trying to dictate venue that way, you have to make sure that you're aware of the underlying tort statute of limitations. Those can frequently be very short statute of limitations periods. So you got to have your eye on the ball there before the insured settles. You got to have that flagged right when that claim comes in, because you might be in Louisiana, you might be in Kentucky, or you might be in states with very, very short statute of limitations. The other thing you want to make sure you do is actually put the at-fault carrier or party on notice. You can't simply rely on a notice letter to your insured to preserve that claim, because if they settle around you and you haven't notified the other party, then you may not likely haven't preserved your right to subrogation, even if you're within the statute of limitations period. So if you get these cases and they're a little tricky, happy to run by these fact scenarios, roundtable them here with any of the folks here, and we'll give you some guidance. But just these are kind of these tips and tricks that we want to let you be aware of, because we see far too many claims just being abandoned because they're non-ERISA or they're fully insured. And so you've got some preemption arguments, you've got some choice of law arguments that you can use. Now, if all else fails and you're still subject to made whole, Nancy's going to walk us through some tips and tricks about how to still salvage a recovery in those made whole states.
Well, we'll try. First slide, now what? So we're stuck with a fully insured plan and made whole controls. What then, or then what? A couple of things to think about right off the top of your head is insist on accurate and fair allocation of damages. You want to get all of the information. You're going to get a letter that says, my client settled this, they were, for this amount, or maybe they don't tell you, they were not made whole, we're closing our file, close yours, have a good day. I know that can be a little jolting at first, but then you just need to take a deep breath and follow some of the things I'm about to talk to you about, and move forward with your evaluation. So first of all, insist on the accurate, fair allocation of damages, and then you have to evaluate the nature of the claim and the feasibility of the injured party being made whole by assessing all relevant factors. And there are a lot of relevant factors, and we'll get to that. And it can be daunting at first, but if you just kind of take it methodically, you can get to a good result ultimately. So you want to look at the type and severity of the injury. Is it a permanent injury, an acute injury? Were they recovered fairly quickly? Do they go back to work right away? There are a lot of questions that you can ask to assess the type and severity of the injury. If they lost a limb, that tells you something. A lot of things that you can look at. And then you want to look at the actual bills incurred. And the bills might not be your own medical bills. There may be first-party bills that were paid. You want to make sure that you're getting from the attorney all of the information on the bills that are related to the accident. And then, of course, you want to know the amount of the settlement funds. And more and more often, we're hearing that the settlement is confidential. So then you write back and say very kindly, I'm happy to sign a non-disclosure agreement for the limited purpose of evaluating this claim, because that is your right to do so. So don't be afraid to do it. Some push back on it, and some just send me an NDA right away. So that's something to have in your pocket to get to the settlement amount. It's not that confidential. You are an interested party, so ask for it. So when you're not able to obtain sufficient information to assess your claim, then you have to go back to what we've been talking about. Consider your relevant jurisdiction. Where are you? And in that jurisdiction, is there a process to assert or challenge whether the insured is made whole? Is there an opportunity for a hearing? Can you intervene? You know, what's possible? And we can help you if you run into a situation like that to determine, you know, where you are and what you should do next. Because you're at the early stages of trying to negotiate, and the settlement maybe has already occurred. So you just want to get those issues out of the way soon. So moving on to slide 2, and backing up a little bit, just broad picture. I'm not going to try to get too case law heavy, but how did the made whole variation state by state in jurisdictions evolve? And basically there are 5 categories, if you will, of the made whole doctrine that the courts either apply or disregard, sometimes willy-nilly. But the first rule is basically that the insurer is made whole. That's a good one. So the insurer is the sole beneficial owner of the claim against the third party, and therefore entitled to the full amount recovered, whether or not it exceeds the amount paid by the insurer to the insured. So that's the first rule. The second one is that the insurer is to be reimbursed first out of the recovery from the third party, and then the insured is entitled to any remaining balance. And the third one is a proration category. So the recovery from the third person is to be prorated between the insurer and the insured in accordance with the percentage of the original loss for which the insurer paid the insured under the policy. And then the fourth rule is that the insured is made whole. So out of the recovery, the third party, the insured is to be reimbursed first with the loss not covered by insurance. That's a little bit of magic language that you can take a look at. And the insurer is entitled to any remaining balance up to a sum sufficient to reimburse the insurer fully, the insured being entitled to anything beyond that amount. A little bit tricky. And then finally, the fifth rule is that the insured is the sole owner of the claim against the third party and entitled to the full amount recovered, whether or not the total received from the third party and the insurer exceeds the loss. So we've got these 5 categories, but in general, the US courts have avoided Rule 1 and they have avoided Rule 5 because they're the most extreme. Obviously, because that creates a windfall effect on either side. But surprisingly, few courts have utilized the proration formula, rule number 3, despite its apparent logic. Instead, most jurisdictions have adopted the insurer whole or the insured whole rule 4 formula. So an examination of the case law is a little bit helpful. So the majority, and I'm just going to quickly list states, I have a few listed here: Alabama, Arkansas, Colorado, Connecticut, Florida, Georgia, Illinois, Indiana, Iowa, Kentucky, Louisiana, Maine, Massachusetts, Michigan, Minnesota, Mississippi, Montana, Nebraska, New Jersey, quite a few states on and on, Washington, West Virginia, and Wisconsin. And the decision most frequently cited in support of the insured made whole doctrine was rendered by the Wisconsin Supreme Court, which we, at MWL, like to argue is the mother of all made whole doctrines in the country, is the Garrity versus Rural Mutual Insurance Company. And it was a fire loss case. And the Wisconsin Supreme Court concluded without discussion that the subrogation provisions in the fire insurance policy and the subrogation receipt did nothing to change the common law rights of the insured. So accordingly, the court held that the insureds were entitled to be made whole before any monies were paid to the insurer pursuant to its right of subrogation. So in other words, not a great decision, but widely cited. And what's more troubling about that decision is that the court essentially completely ignored any distinction between legal and conventional subrogation. And then the Montana Supreme Court in Skage, am I saying that right, Ryan? Skage, how do you say it, all you Montana people? Skage versus Mountain.
Or something? Yeah, I don't know.
Not that it matters that much. Like in Garrity, the Montana Supreme Court disregarded the policy provision and concluded that the insurer's legal right to subrogation made the policy provision unnecessary and of no effect. And then the Tennessee Supreme Court weighed in, and they adopted the insured whole rule in the case of Wimberley versus American Casualty Company. And the Tennessee court reviewed the cases or the decisions at Garrity, Skage, and Peterson, an Ohio case we'll talk about in a second. And that court adopted the decisions in Garrity as the better reasoned authority. But then a subsequent decision by the Tennessee Supreme Court limited a little bit in a kind of an odd way in the case of Eastwood versus Glen Falls Insurance Company. So in the Eastwood case, they agreed with the insurer that no settlement, the parties agreed that no settlement would be made with the tortfeasor without the written consent of the insurer, but then they settled anyway without any notice. So the Tennessee Supreme Court held that the insureds could not enter into such a settlement agreement without incurring further liability to the insurer because they failed to obtain its consent to the settlement. So the court distinguished its prior decision in the Wimberley case, noting that the insureds in Wimberley had sought and did receive the insurer's consent to the settlement. So after going through all of that analysis, the court readily enforced certain contractual conditions contained in the subrogation receipt while simultaneously disregarding others and the contractual conditions of the insurance policy pertaining to subrogation. So in other words, this is a majority opinion adopted by many states, but it's an opinion without a lot of cohesiveness. So you have to know where you are, what state you're in, and exactly how they apply the made whole doctrine. Now, the minority rule is that the insurer should be made whole. Now, California, under certain circumstances, and that gets a little bit complicated, Idaho, Ohio, Virginia, and Wyoming adopt this rule. And the most frequently cited decision supporting the insurer whole doctrine rendered by the Ohio Supreme Court in the Peterson decision that I discussed a little bit earlier. And it's another fire loss case. So after the insurance settlement, the insurer and the insureds commenced an action against the tortfeasor together. So each party employed its own attorney, they collaborated in conducting the litigation, and each party paid its own expenses. And subsequent to that, or the way that they did it procedurally, is that they filed a DEC action seeking indemnification up to the full amount of their loss plus counsel fees and costs. And they had a policy language that was pretty strong, and it said this company may require from the insured an assignment of all right of recovery against any party for loss to the extent that payment therefore is made by this company. And then they went on to execute a subrogation receipt, and it's considerably longer, but anyway, it was relevant to the Ohio Supreme Court. So the Ohio Supreme Court relied on these provisions, and they found that the insured had assigned their entire right of recovery to the extent of the payment to the insurer. And because the court determined that the policy provision and subrogation receipt amounted to an assignment, they held that the words all right of recovery in the policy would be without meaning if the insurer were not accorded priority of the funds. So cooperation is also important in Ohio. They later found that an insurer entitled to priority of the proceeds were based on equitable principles of subrogation. And in the case of Urban versus Garner, the court held that the insured is not entitled to be made whole first from the proceeds of a recovery if the insured refuses to cooperate and provide assistance from the insurer. So under the Ohio law, only when an insurer refuses to cooperate, and it goes both ways, in the pursuit of the third recovery, is the insured entitled to be made whole first. So even though it's an Ohio case, you need to scrutinize the contractual language at issue before concluding that the insurer is entitled to be made whole first. And you need to consider when an insurer impairs a claim. So the insurer whole rule has also arisen in cases in which the insured has impaired or prejudiced the insurer's rights. So several courts have held that the insurer is entitled to be made whole first even though the jurisdiction's general rule is to the contrary.
Nancy,
The next,
sorry to cut you off, but we're running up against the clock, and I wanted to make sure that we got to your kind of your analysis, your detailed analysis that you've got planned.
okay, I was just about done.
Sorry.
The last item I was going to bring up was that several courts have held that allocation of damages makes a difference. So if you can bucket property versus medical versus future, those are all important allocations that you want to consider. You need to find out about them. But say you have a big case and you don't want to walk away from it, you can go through a very detailed analysis in slide 3. And we'll run through that very quickly. The first thing you want to take a look at are the damages. You want to find out with specificity all of the economic out-of-pocket expenses, medical hospital bills, cost of prescription drugs, lost wages, etc., and the non-economic damages, pain, suffering, inconvenience, mental anguish, all of those things. You want to be able to assess that as distinctly as you can. And then you will deploy a statistical method. So based on averages that incorporate data from local and statewide verdicts. So what you'll be researching are local and statewide verdicts mirroring your situation as closely as possible in order to come up with basically a multiplier. I'm sure you're familiar with that term. Personal injury attorneys use it all the time to value a case at the early stages. Then you need the exact figures regarding economic damages. So to develop a working multiplier range, which the multiplier is a ratio based on the total verdict or settlement amount to the economic damages. Again, by researching local and statewide verdicts with similar economic damages. And obviously you want to try to find verdicts that mirror your elements of your case. And you have to analyze that figure. I'm trying to scroll, I'm getting a little bit out of my range here. So you want to be able to determine a bottom line multiplier and a top line multiplier. So you're going to throw out cases at the top of the award spectrum. You're going to disregard cases at the bottom. And then you can come up with an average, and you are able to come up with a dollar figure that determines whether or not this person was made whole. And then you have to obviously review and apply the made whole law in your jurisdiction and apply it to your situation. And oftentimes, if you're going down that analysis and your opposing counsel realizes that you're going through this type of analysis, you can come to an agreement.
So this is something you use pretty successfully in Washington, right?
Yes.
Yes. So how do you specifically deal with the the notion that when they throw out these big non-economic damage claims and say, well, he's never going to be made whole because he was tragically injured, and so I mean, how do you convince them to get down to a reasonable multiplier based on the relationship between economic and non-economic damages, and what multipliers do you typically use?
Typically, if it's a catastrophic loss, there will be something in the litigation, either a life care plan or an expert report, and we just analyze that as it comes in. And you can often find that the representations that were made to you by the attorney early on are disputed by either the expert report or a life care plan. So it's really more art than science of sharing information. But if you approach it that way, that my client's requiring a detailed analysis, and the only way that we're going to get here is to attempt to assign a multiplier, and I just lay out, this is the information I'm going to need from you, and it's kind of a long list of the information that they have to provide back to you. So they tend to kind of they get serious about it, and either they'll walk that path with you. I'm trying to get to the place of figuring out a dollar figure that makes them whole, or they'll just start to settle with you. It can go either way. But
yeah, I can imagine that there's going to be a lot of situations where they just don't want to share the information, either because they don't like what it's going to say, or you know, you know, or they I guess it would just, you know, preferably not share it because they're concerned about what your client might do with it, right?
Right, sure. Yeah, that's a consideration. One of the last points I was going to make, and I know we're starting to run over time here, is that you can review the attorney's professional responsibilities in the jurisdiction. And the model rules require that if the attorney is in possession of property to which 2 or more persons, and you're a person, making a claim toward that property, that it shall be kept separate until the dispute is resolved. Washington State, for example, goes a little bit further, and it says the lawyer must take reasonable action to resolve the dispute, including, when appropriate, interpleading the disputed funds. So we have been successful in saying, hey, we're not resolving this dispute. Let's interplead the funds. We'll go to court. We'll do some discovery, and then I will find out all of the information that you're not really willing to share with me. And of course, I don't say that, but that's the forum that you go to be able to find out all of the information that you're entitled to in order to evaluate the claim. Yeah, evaluating made whole is difficult to do, and you are relying on opposing counsel to provide you with that information. So if you can get in front of or in a courtroom, then you're at an advantage because you can do that discovery. So try not to go there. I mean, obviously, we'd like to resolve these cases, but there's more than, you know, there's more that you can do to get to a better place. Made whole is not the end, and you certainly shouldn't take a 2-paragraph letter from the attorney just advising you that their client had not been made whole on its face. And
Sure.
If we all keep doing that, then we'll all keep getting those letters. So we need to push back to the extent that we can.
Well, thanks, Nancy. Well,
Real quickly, Ryan, let me just squeeze this in there.
Yeah.
Also consider a litigation agreement. That is the most logical way to provide early on for sharing of the recovery and the expenses. You know, you can do your arguing of, you know, choice of law. You can get all that out of the way, educate opposing counsel, and try to come to an agreement on the front end. Now, of course, that presents its own difficulties because you don't know enough to calculate, you know, the loss. You know, there's some unknowns, but you can draft an agreement. You know, that's ideal if you can do that. So we'll help you, you know, help come up with a litigation agreement if that's appropriate for your case.
Yeah, sure. Awesome. Great conversation today, guys. But for next month, let's kind of preview where we're going. I'm going to be out. I think I'm going to have a guest in my place, Attorney Steve Smith. But Catherine, what are you guys going to talk about next month?
Coordinating benefits. So mostly we're going to be talking about PIP, no faults, med pay, a lot of focus on states where those policies are larger, New Jersey, Florida, New York, Michigan.
So you're going to, I mean, is it going to just be coordination, or are you going to be talking about what happens when you pay and chase in those no fault states?
Pay and chase, coordinating up front, dealing with overpayment issues, which can be particularly complicated where the no fault is paying according to some sort of fee schedule.
Sure. And what states are we what are the problem states when it comes to these issues?
The fee schedule is definitely New Jersey and Florida, I think, are where we see some of the biggest issues.
Awesome. Well, I'll look forward to watching it after I come back. But join us then next month, August 23rd at the same time, and we'll be covering these ERISA and PIP and no fault issues. So thanks everyone for joining us, and we'll talk to you next time.
Thank you.
Thank you.